Hello, everyone. I'm Rita Peters, Senior Vice President for Convention of States Action, and I am coming to you today with some really exciting breaking news out of Kansas. The United States District Court for the District of Kansas has just delivered a decisive victory for Convention of States proponents. The court has just struck down a provision in the Kansas Constitution that purported to require a two-thirds supermajority vote for the Kansas legislature to apply for an Article 5 convention. The case is Thompson versus Masterson. This litigation came about in 2023 after simple majorities of the Kansas Senate and the Kansas House voted to pass our Convention of States resolutions applying for a convention to propose constitutional amendments that would impose fiscal restraints on the federal government, limit its power and jurisdiction, and set term limits for federal officials and members of Congress. Now, despite the majority votes in favor of the resolutions, House and Senate leadership ruled that they had failed because of Article 2, Section 13 of the Kansas State Constitution, which purports to require a supermajority vote for all Article 5 applications. Senator Mike Thompson and Representative Michael Murphy, both COS champions who voted in favor of the measures, filed the lawsuit in Kansas's federal district court to challenge the state constitutional requirement. And our very own Convention of States co-founder, Michael Ferris, acted as co-counsel in the case. So here's the basic issue. The plain text of Article 5 of the U.S. Constitution vests the power to apply for a convention solely in the state legislatures. And an abundant body of case law establishes that state constitutions can't interfere with the authority given to state legislatures by Article 5. Of course, the supremacy clause of Article 6 gives the U.S. Constitution precedence over conflicting state laws, even the state constitution. So the U.S. District Court for the District of Kansas has now agreed. The court first dismissed the idea that Article 5 controversies are non-justiciable political questions, which is an argument you hear from a lot of Article 5 opponents. The court then went on to examine a number of prior cases on relevant Article 5 issues before concluding that the purported supermajority requirement for Article 5 applications could not stand. As the court explained, the application power is conferred not by state law, but by Article 5 itself. Now, while the narrow effect of this litigation is to strike down a state constitutional provision, its broader effect is actually to enhance the ability of state legislatures to use their Article 5 power to restrain federal overreach. That's a really good thing. Now, of course, it is possible that the Attorney General could appeal this decision, but I see no weaknesses in the district court's reasoning. So the AG would be really hard-pressed to find a good argument on which to base an appeal. Now, where does this leave us? In terms of Kansas passing the COS application, it leaves us just on this side of the finish line. The COS resolution, SCR 1604, passed the Senate earlier this year by a supermajority vote of 29-11, and it remains pending for a vote in the Kansas House of Representatives. Now, we have strong support in the Kansas House, so hopefully that final vote will happen quickly when session starts in January. But there's one more thing. This decision really puts to bed the conspiracy theorists' claims that the Article 5 convention process is some big mystery and that courts can't intervene when needed. We knew this wasn't true, and this court ruling is just more evidence that the conspiracy theorists are wrong. So, this is a great day for COS, and we're very excited to bring you this news today. Stay tuned to see what happens in Kansas in the future. We'll keep you posted. Thanks for joining us.